Welcome everyone to ADA Compliance and Website Accessibility from SilverTech. We are a digital agency working to redefine how businesses engage with and understand their customers. To get the most out of today's webinar, here are a few tips. The initial presentation will last about 30 minutes. There'll be a Q&A afterwards, so if questions come up along the way, please feel free to post in the webinar chat pane. The slides, recording, and tools will be made available after the broadcast. Again, thank you so much for joining us today. I am your host, Ian Hughes, content strategist here at SilverTech. I write for SilverTech's blog, podcast, and our webinars. I'm pleased to introduce SilverTech's ADA experts. They both bring a unique perspective to the issue of website accessibility. First, let me introduce Paul Cream, our Vice President, General Counsel. Paul has over 30 years of experience practicing law and works with senior leadership to ensure that SilverTech is consistently pursuing strategic goals, and he also provides day-to-day contract review. Welcome, Paul.
Good afternoon.
And also joining us today is Rafael Verana, our UI UX designer. Rafael is a UI UX designer with over 4 years of experience exploring and applying accessibility standards in design and development. Welcome, Raf.
Hi, thanks for having me.
On the agenda today, let's take a look. We're here to discuss, we'll get in first to a brief history of the Americans with Disabilities Act, that's the ADA. We'll talk about the ADA, website accessibility, and some lessons that can be learned from recent cases. Then we'll discuss the World Wide Web Consortium, that's the W3C, and the Web Content Accessibility Guidelines, WCAG. And then, of course, we'll have that Q&A at the end. Now, we are here today to discuss the ADA and specifically website accessibility, but first let's more generally begin with an introduction to the Americans with Disabilities Act. Signed into law in 1990, the Americans with Disabilities Act, ADA, gives civil rights protections to individuals with disabilities similar to those provided to individuals on the basis of race, color, sex, national origin, age, and religion. Importantly, it is a civil rights law. It guarantees equal opportunity for individuals with disabilities in public accommodations, employment, transportation, state and local government services, and telecommunications. Paul, essentially the purpose of the law is to make sure that people with disabilities have the same rights and opportunities as everyone else. Is that correct?
Yes, it is. The purpose of the law is to provide access for people with disabilities as long as costs are reasonable for the companies that have, in this case, websites of what we're talking about today. But the same laws apply to physical locations. That's why you see ramps in buildings, wide doorways, and other types of accommodations that make buildings accessible to people.
Mm-hmm. And as we'll get into today, those same accommodations that essentially apply to website accessibility. In 2018, it was expected that the Department of Justice would issue regulations regarding website accessibility. We'll discuss this a little further on. So to add further clarity, U.S. Attorney General signed the ADA Amendments Act Final Rule, and this was back in 2016, October 11, 2016. In summary, the ADA Amendment Act is an attempt to broaden the definition of disability. Paul, what does it mean for ADA cases that question whether an individual's impairment is a disability under the ADA should not demand extensive analysis?
Well, the recent changes to the law expanded the definition as a response to a 20-year period of cases which narrowed the definition.
Okay.
So the recent cases, and in this case we have a First Circuit Court case that we'll discuss later, are allowing the plaintiffs to survive summary judgment or the motions to dismiss.
Mm-hmm.
So in other words, the courts have shown, even absent a standard, that they were going to allow cases to move forward, therefore making it pretty much a requirement for any company to really deal with accessibility with their website.
Mm-hmm. So due to uncertainty about what specifically the meaning of physical and mental impairments was, the term is now illustrated with additional examples, including dyslexia, attention deficit, hyperactivity disorder, ADHD. Key takeaway then is essentially the person making a claim may not have to carry as heavy a burden to prove their claim. So who does the ADA apply to? In short, businesses covered by the ADA are Title I, that's equal employment opportunity for individuals with disabilities. So that's private employers with 15 or more employees. Title II covers non-discrimination on the basis of disability in state and local government services. And that's public entities at state and local levels, which includes both physical and programmatic access to all programs and services offered. And then there's Title III. This is the non-discrimination on the basis of disability by public accommodations and in commercial facilities. This is businesses operating for the benefit of the public and nonprofits. In regards to the website accessibility, as I've mentioned, the Department of Justice had promised guidelines, but in 2016 they turned their attention to those covered under Title II. We are seeing, and we'll get into recent cases, how that may apply to those covered under Title III. Let's now discuss the ADA, website accessibility, and some lessons from recent cases. Here are excerpts from a statement from the U.S. Department of Justice, and this is the fall of 2015. The ADA's expansive non-discrimination mandate reaches the goods and services provided by public accommodations using internet websites. The inability to access websites puts individuals at a great disadvantage in today's society, which is driven by a dynamic electronic marketplace and unprecedented access to information. Paul, I think this is a telling part of the statement. Really, beyond goods and services, information available on the internet, it's become a gateway to education, socializing, entertainment. Your thoughts there?
Well, I think the sites that are probably going to be challenged by plaintiffs or by some of these advocacy groups are sites which do a lot of transactional activity. In other words, banking sites, you use the bank site to do your banking. People might not even go into the bank anymore. They might use the banking to pay, the electronic portals to pay bills, move money, do all the other things. Same with hospitals. They're going to use the site to find doctors, pay bills. In other words, transact with the hospital without actually going into the hospital. And then the last larger area or types of company or entities that are being targeted are universities, online content. So sites that are transacting activity that require people to actually do something other than just look at something on a site, those are the targeted websites.
Yep. And from your examples there, myself personally, I got my bachelor's degree online. I opened my bank accounts online. I don't think I've stepped into a bank or onto a university campus. Yourself, Raph?
Yeah, my bank doesn't even have a physical location, so I use USAA.
You do, yeah. And they are all online in this area. So, preventing somebody from accessing those sites is really closing their doors.
I think any entity, any entity should be accessible, but these are the ones that are going to be targeted first. And any company or entity needs to think of their website as the front door to their business.
Exactly, yep.
So you would build a ramp to allow people to come into your building. Therefore, you would make your portal, your website, accessible to as many people as possible.
Briefly, I'd like to touch upon the Section 508 amendment to the Rehabilitation Act of 1973. So Section 508 was enacted to eliminate barriers in information technology, to make available new opportunities for people with disabilities, and to encourage development of technologies that will help achieve these goals. Now, there's nothing in Section 508 that requires private websites to comply, unless they're receiving federal funds or under contract with a federal agency. But I think it does point us towards what may become commercial best practices and involuntary or voluntary standards and guidelines, such as the World Wide Web Consortium, W3C, Web Accessibility Initiative, the WAI. So though we're not going to see guidance, or at least we don't expect to see guidance as we had thought in 2018 for private websites covered under Title III, we are seeing cases moving forward on a case-by-case basis. We'll get to specifics shortly, Paul, but more generally, can you tell us what you're seeing in, say, the First District and out in states like Pennsylvania we saw activity?
Well, we've seen certain states seem to be targeted and certain types of entities seem to have been targeted first. And again, this is from conversations with our clients and people who are talking among our clients who may not in fact be clients, but they've gone out and talked to other people who are similarly situated.
Yeah.
And Pennsylvania seemed to be one of the first states that seemed to be targeted because there was one particular law firm that was sending out lots and lots of demand letters. And then there's also been cases in the First District. There's been first cases in almost every part of the country. And the problem is each state is now being left with dealing with things on a case-by-case basis. And at least in the First District, which is New Hampshire or New England, the New England states, the court has come down on not allowing the case to be dismissed. In other words, the case is moving forward.
They're moving forward, yeah.
So that tells companies that they need to think about making sure they're making their sites accessible, because either they're going to get a demand letter from some law firm or advocacy group, and they're not going to be able to just merely file a motion to dismiss and get rid of the case.
Yeah.
So that's what's going on. And absent guidelines, you're going to have to go by best practices, which we'll talk about later.
I think the key takeaway then, and this is a line from your blog post on the topic, Paul, is it's a certainty that at some point you may want to make your website ADA compliant. Now, at this point, we're not going to dive too deep into the specifics of each of these cases. We've chosen 4 to take a look at. I think that will give us insight into where guidance will go or to what standards you may have to adhere to. This first one that we're taking a look at is the National Federation of the Blind versus Target Corporation. Initially, this case back in 2012, initially Target argued that the website was not a place of public accommodation. However, the court found it is clear that the purpose of the statute is broader than mere physical access, seeking to bar actions or omissions which impair a disabled person's full enjoyment of services or goods of a covered accommodation. Paul, I think the key takeaway is that a website may be considered a place of public accommodation.
That's correct.
This next case is interesting. This is the National Association of the Deaf versus Netflix. What if you don't have a physical location? As Raf had mentioned earlier with USAA, you might be thinking that the ADA will not apply, but there's now precedence for such application. So Netflix's Watch Instantly website was a public accommodation subject to the ADA, even though Netflix has no physical place or public accommodation. So therefore, the ADA covers the services of a public accommodation, not services at or in a public accommodation. So Paul, the key takeaway here, you may not need to have a physical location.
Well, I think the idea is if that is the way you're transacting business, then if you're transacting business, your services need to be accessible to anyone who wants to use your services.
Yep.
Or buy product.
The Department of Justice versus Peapod.com. This settlement shows that the DOJ is looking closely at the accessibility of websites and mobile apps and may remain aggressive in its enforcement efforts. And at a minimum, the DOJ may require companies to comply with WCAG 2.0 Level AA standards, which we'll get into shortly. Before we dive into that topic, Raf, thoughts on mobile applications falling under the ADA? Are Level AA standards, are they difficult, or is it any different to do it for a mobile app as it would be for your website?
It's definitely different. It's a shift in perspective, but it's not more difficult per se. Though the small screen size is definitely a larger issue. Really, it depends on the nature of the app, of course, but when you're dealing with, services like banks or shopping, they're more likely to be complex. So basically, you just need to make sure you follow mobile best practices and the ADA or WCAG standards that pertain to mobile the most, such as you don't have any timed inputs, you don't log people out while they're in the middle of performing some action, there's no aggressive flashing, things like that. So as long as an app is well prototyped in advance and thought out and developed to be accessible in the first place, it shouldn't be more of an issue than desktop.
Yeah, I just want to focus on the last thing you were saying there for a moment. Build and thought out in advance, I think, is the key. So if you're moving forward with any sort of redesign or building a mobile application project, I think the key from what you're saying there is to begin with accessibility in mind as you move forward.
Yeah, and making sure that you're taking the time to wireframe and prototype and think through possible actions and hangups before you dive into development and figure out these issues as you come across them.
Sure. A lot easier to build it than it is to kind of retrofit and fix it. Yeah. The final case is the most recent one we'll take a look at. And this one is currently working its way through a federal district court here in New Hampshire. We alluded to it earlier. It shares many similarities with the 3 already mentioned. In fact, in the memorandum order, the Netflix case is actually cited. Let me read through just a couple of points on this one. This case is Access Now Incorporated, which includes several plaintiffs who are blind, versus Blue Apron. Don't know them. They're the ingredient and recipe meal kit service. A lot of ads on TV, so I'm sure you're aware of this brand. Pretty big now. Paul had actually shared a copy of the memorandum order with me ahead of today's presentation, and I was struck by the following. Title 3, which prescribes disability-based discrimination that prevents the full and equal enjoyment of the goods, services, facilities, and so on, as we mentioned. So it's showing that cases are moving against entities under Title 3. Another point that I thought was striking was that the plaintiffs alleged that Blue Apron violates Title 3 by not making its website sufficiently accessible to blind and visually impaired customers. And then the website itself was just not compatible with screen readers. It was largely unusable due to various accessibility barriers. So from the judge's conclusion, Paul, for the reasons discussed herein, the court denies the defendant's motion to dismiss the complaint. Are we going to see more of this, Paul? Cases moving through
I don't think
district
there's
courts?
any doubt we're going to see more, because I think these groups, as they enjoy a little bit of success, we're just going to target more and more companies. As a matter of fact, our sister company just got a demand letter just this week.
No, really?
From the same group, demanding that they either remediate their site or pay a settlement.
Really? Yeah.
So that's what's going on. Is companies are finding themselves in a position where they need to remediate or they need to litigate. And the problem with litigating is the summary judgment or the motion to dismiss avenue that might allow you to get rid of the case relatively expeditiously and relatively inexpensively is probably no longer going to be available.
Right. Yeah.
So, and we know in this area, at least, the first district's already made the decision, so the precedent's there. So in other words, if you got a demand letter and you're within these certain districts that are coming down, and it's more than 50-50, it's a majority of the district courts in this country are allowing these cases to go forward. You're now presented with the option of you're going to have to either remediate, fix your site, or pay some settlement amount. And if you decide to not pay it, your litigation expense is going to be more than the settlement amount. And then you're going to have to remediate your site anyway.
Yeah, yeah.
So to me, it just doesn't seem to make sense not to deal with it, because you're going to have to deal with it one way or the other. Just because you settle with one group doesn't mean another group's not going to come in right behind you and make exactly the same claim.
Did a similar thing happen with the ADA for physical locations when it was first, 1990? If you didn't have a wheelchair ramp to access, were there similar groups kind of banding together with suits? Or?
Well, I think the thing with buildings is because not as many people have to use a building.
Sure, yeah.
Is will go to a website. I think it didn't have the same kind of reaction. Secondly, I think a lot more people, because it's concrete, bricks and mortar, and something that they can actually look at, the concept of putting a ramp in was probably something people just decided was not such a big thing to do. Making your website accessible is harder for people to grasp, but the problem is every day thousands and thousands and thousands of people are going to go to your website.
Right.
How many people are going to walk into a building?
Yeah, very true.
Not as many. So not as many people are going to target a specific building for not being accessible, whereas how many people are going to go to a Blue Apron website on a daily basis? So I think that's the difference. So I think that's why you're seeing this rapidly exponential growth in litigation, because there's just so many more people who are out there going to websites. And again, that's how more and more people do business.
It is, yeah.
I mean, there's a lot of people that can't imagine going into a store anymore, or going to the mall, or going out physically shopping. Why should I do that? I'll go online.
Right.
So I think, and that's not going to change.
No, customer expectations are fully there.
So I think that's why you're seeing a different dynamic than you did when there was talking about physical locations.
Interesting. There's one item from this case, Raf, that I just want to get your insight on. So the plaintiffs in this case are blind, and they're alleging that the website itself is largely unusable due to when they're trying to use their screen readers. What is a screen reader, and how, what is it looking for on a website?
So it's exactly what it sounds like. It will actually read out the content on a website. So it doesn't go into the markup, the HTML. It'll read whatever plain text is visible on the site. So that means that any link that you have, any navigation, not only your paragraph text, but also your footer. If you have disclaimers, like if you're a bank and you've seen that, 9-pixel font at the bottom, they read all that too. So that's an assistive technology that people use if they have poor visibility, that they can use to hear what a website is saying instead of reading it.
So in the case of Blue Apron, what do you think might be happening with the screen readers? Is there like images without alt text that maybe they're skipping over? Is there maybe just a lot of visual cues that that you or I would think naturally, like we know to scroll down here, but if there's not anything programmed into the site itself? Yeah,
so exactly. So improperly filling in alternative text for images. Maybe they were using images instead of text.
Sure.
Perhaps they were, for example, if they're misusing their markup, so if they're using images that could be better used as background images in CSS, but instead they're inline and they don't have that alt text. or they could also be, they could have hidden links. They could have navigation which is not sequential and logical, or they could have keyboard traps. So for a screen reader, they would fall into the same trap. They would read whatever is next down the page, but maybe that takes you to halfway down the page instead and it skips content. Or your content is just unreadable, or it's an inline frame, an iframe, and it can't read that. So there's multiple pitfalls that a screen reader can fall into.
Okay, well, we'll get into how to deal with many of those in kind of the second portion of our presentation here, but thank you for sharing that on screen readers. Key takeaway, I think, is the recent cases, as Paul suggests, may be only the beginning of the explosion of website accessibility cases. Courts may be increasingly reluctant to dismiss website accessibility lawsuits at the beginning, and cases will continue to discovery. Let's get into the World Wide Web Consortium, that's W3C, and the Web Content Accessibility Guidelines, WCAG. I think this is where we'll gain an understanding to where guidance will ultimately go and, where many of these cases are going to come down. Leading the web to its full potential. So the World Wide Web Consortium, W3C, was founded in 1994 by Tim Berners-Lee, often credited one of the founders of the World Wide Web. I'd like your thoughts here, Raf. Since the beginning, the internet has essentially been, the whole philosophy has been to include people. So, your thoughts?
Yeah, I mean, it's called the World Wide Web, so it's meant to, connect the world and people together. For some, the internet is the only way to interact with other people and services. And some information nowadays, especially, is only available online. Manuals, training manuals, videos, things like that. So why would you want to bar people from accessing that?
So if your website is doing that, you're almost working against what the entire point of the internet is, really.
Why bother having a site? Yeah.
Sure. In 1999, so the Website Accessibility Initiative, WAI, and the World Wide Web Consortium, W3C, they created the Web Content Accessibility Guidelines, WCAG. So in 2008, these standards were updated to WCAG 2.0, and this has become an ISO international standard for the web. A number of governments already require that public websites meet these standards, including those in the EU and Australia. And as we saw with the Peapod case, the DOJ may make WCAG level AA compliance the new standard. So WCAG 2.0 established 4 principles, POUR, for which there are 3 levels, A, AA, AAA. Let's review the principles first before we dive down into the levels. So P, for perceivable. Information and user interface components must be presentable to users in ways that they can perceive. Provide text alternatives for non-text content, which we mentioned earlier. Provide captions and other alternatives for multimedia. Create content that can be presented in different ways, including by assistive technologies, without losing meaning, as we discussed in Blue Apron, and make it easier for users to see and hear content. Operable is the O in POUR. User interface components and navigation must be operable. Make all functionality available from a keyboard. Give users enough time to read and use content. I think Raph mentioned that in the discussion of mobile applications. Do not use content that causes seizures. Should be an obvious one there. Help users navigate and find content. Raph, one of those points there was about building a website and planning for making all functionality available from a keyboard. How do you do that? How does that work?
So any website or web app is automatically usable by a keyboard just by using the tab key. So what that means is actually don't interfere with the tabbing functionality in order. As long as the markup is correct, it's logical, it's sequential, which is another WCAG criteria. As long as that's in order, then good keyboard functionality will automatically follow. So browsers have a default styling for focus indicators to show where you're actually tabbing, as long as you don't do anything to style that in a way that it's hard to see where you're currently at as you tab.
Sure.
As long as your markup is not, for example, using CSS positioning to move things out of order visually so that it doesn't match what the positioning is in the source code. Making sure that you don't have tabbed content that you can't access through tabbing. As long as none of that, as long as you're not getting in your own way, you're in the clear.
Okay, yeah, I love that. Just kind of don't get in your own way.
Yeah.
It should kind of naturally be accessible from a keyboard.
Yeah. Another thing as well is you can manipulate tab index using source code with HTML. So, as long as you don't have that out of alignment, or you can use it wisely to put things back into alignment so that it's a user can flow through the page naturally.
Here's the U in poor, and that's understandable. Information and the operation of user interface must be understandable. So make text readable and understandable, make content appear and operate in predictable ways, and help users avoid and correct mistakes. The R in poor is robust. Content must be robust enough so it can be interpreted reliably by a wide variety of user agents, including assistive technologies. In other words, don't use tags or code that only certain browsers understand. You want to maximize compatibility with current and future user tools. So for each of the WCAG 2.0 principles, there are guideline levels. There's A, AA, and AAA. Similar types of accessibility features are addressed in each, with AA having more than A and AAA having the most criteria to meet that level of accessibility standard. Ref, how many websites out there, we don't have to get a number on this, but how hard is it really to achieve AAA accessibility?
Yeah, I don't know how many nowadays can be AAA, because the more complex the site, the harder it is to reach. AAA requires things like not only captions on video, but sign language interpretation on video, which you can imagine is difficult to achieve. So even the WCAG acknowledges that you should strive for AAA, but you may only meet AA. So that's just something to keep in mind, that you should always aim to be as accessible as you reasonably can.
Yeah, it's interesting to note though, so it does kind of evolve. So if you have kind of your video under AA, you'll have to provide transcript for that video, but under AAA, you actually have to have a sign language interpreter on there. So it's interesting to see how the guidelines work. So again, we want to be striving for strive for AAA, but if you're landing in AA, you're okay. Businesses do not have to comply with all listed criteria to meet conformance, obviously. So that means, if you don't have video on your website, you don't have to worry about,
not your problem.
having a sign language interpreter on there. So let's take a closer look then at WCAG guideline level AA. So the main items are that captions are provided for audio content, transcripts provided for video content headings and labels are descriptive of topic or purpose, and the user must have the ability to resize text up to 200%, and navigation features are consistent. Raf, could you tell us what it means for content headings and labels to be descriptive of topic or purpose? What does that mean?
So that's just for general understanding, and so that people can perceive and comprehend what's going on your webpage, so that people can know what the purpose and the content of the text is before they actually engage with it. That's helpful for people that are maybe have lower visibility using a screen reader, so they know what they're about to get into before they actually dive in.
Excellent. And then what does it mean for navigation features to be consistent?
That's also, so obviously as you're going from page to page, you want to know that, you're within the same realm each time. You want to know that you know what to expect as you go between pages. And it also helps to establish where your content is. So if you always know that, my navigation is on the top right, you can use a site quicker as you progress into the site, because you automatically know where to go and you know where the content isn't. It's not going to be on the top right.
Okay, so if you start with your home page, navigation's the top right, you go to a landing page and all of a sudden it's in the top left, and another page it's down in the bottom somewhere. I mean, I can think, regardless of having a disability or using assistive technology, that's just doesn't sound like a best practice to move that stuff around.
Right, you would almost wonder if you're even still on the same site.
Sure, yeah. Accessibility then overlaps with other best practices such as mobile web design, device independence, multimodal interaction, usability, design for older users, and search engine optimization, SEO. Thoughts there, Raf?
Yeah, I mean, accessibility really is the sum of every well thought out and implemented part. It's not a checkbox with one line item. It's multiple small pieces coming together, that you have a pleasant user experience, but also that it's accessible and people can actually perform what they're setting out to do every step of the way.
Of course. And another key point in there that is tucked away, design for older users too. I think a lot of these accessibility guidelines that we're talking about are, a best practice to make sure that the older populations, that demographics that may be coming to your website have the accessibility that everyone should have. Let's take a look at some of the best practices that will help you achieve level AA. You don't want to rely on color as a navigational tool or as the sole way to differentiate items. Raf, could you clarify this point? There are kind of certain color ratios that you should strive for?
Yep. So for AA, it depends on whether you have large or small text, and those are established quantities. I believe small text is 18 pixels in bold and large is 24 and up.
Mm-hmm.
So it ranges from 3:1 contrast ratio to 4.5 and 1.
Mm-hmm.
So if you have larger text, you only need to have a 3:1 ratio. If it's smaller, anything from 18 and below, as I said, you're going to want 4.5 to 1.
Images should include alt text in the markup code. Complex images should have more extensive descriptions near the image. Let's pause for a moment to just talk about alt text for images. Raf, how descriptive should they be?
Well, first I want to point out that not all images do need alt text. It's images that serve a purpose or function.
Oh, okay.
If it's an image that's purely decorational, you can, as long as you have the alt attribute in your markup, you can leave it empty or use null. Otherwise, good alt text is, as I said, it describes what the function is of the image. You don't need to say, this is an image of a flower. If the image performs some kind of function for the site, then that's what you should be describing, such as link to a flower shop.
Okay, yeah, that makes sense. Functionality should be accessible through mouse and keyboard and be tagged to work with voice control systems. We talked a bit about the keyboard accessibility. You must provide transcripts for podcasts. And if you have video on your site, you must provide visual access to the audio information through in-sync captioning. And sites should also have a skip navigation feature. What is a skip navigation feature, Ev?
So exactly what it sounds like. It's especially useful for screen readers. Basically, it just says you can use it as an anchor link within the page that will take you beyond your main menu, your navigation. And that is because people that use screen readers or keyboard, they have to go through individually line by line every single item in your menu, and that can be excruciating if you're doing it maybe even the second time around because it's on every page.
Sure, yeah.
So skip navigation allows you to clear that section of your site and get to the content. So if you're going from the home page to an inner page, now you're familiar with what the menu is and you're seeking actual content, actual information. You don't need to hear the menu for the second, third, fourth time.
Excellent, yeah. Well, that's drawing us about to the close of our presentation. Hopefully we've sufficiently covered the history of the Americans with Disabilities Act, how it'll apply to websites, and the legal necessity for ensuring your site is ADA compliant. I have included a copy of today's presentation in the handouts. You can also access our ADA checklist in the handout section. There are PDFs over there, and you can download those. And I will follow up after today's presentation with an audio recording and an on-demand access to the webinar. Let's just see if we have any questions come through. Don't see any that have popped into the chat pane, but I have a couple myself. What steps could I take after getting off the webinar to make sure my website is ADA compliant is my main question.
So first of all, you would definitely need to have some sort of foundation. You don't need to be an expert, but some working knowledge of the ADA or the WCAG guidelines rather. So just going through and reading, the large picture, getting a large picture of what it entails, and then actually applying those to your site. So you can you can assess it manually using what you know. There's scanning tools out there, or you can hire someone who will do it for you.
Sure.
And then I would say put an action plan together to actually look through your site and see what needs to be done.
Excellent. And you mentioned tools. Do you have any tools that you would recommend for automation?
Yeah, so there are actual, full tools that will scan a whole site for you and return a report. But those are usually behind, a price tag.
Sure.
You can use extensions, browser extensions like Chrome. I personally use SiteImprove, and they also have a full tool which will, like I said, scan the whole site, but their extension, you would have to do it page by page. So what they do is they actually go through and check an entire page and see what matches what criteria and whether usually they pop up the ones that you don't meet.
And that was SiteImprove, is that what you called it?
SiteImprove.
Yeah.
Yep.
So even if you didn't get, the full picture of everything, it would at least give you kind of a sense of, this is kind of the work that we have to do to get this into compliance.
Place to start.
Excellent. Would some changes be more important to make than others?
I do think so, yeah. I think that you should base the changes that you prioritize off of how much they would help and how much they would help comprehend your site. So what that means is that maybe taking care of color contrast, if the bulk of your content is using a lighter font, maybe that's a little more important than, say, working on other issues like your captions.
Yeah.
Not that they're not all equally important, but some do help towards the comprehension of your site more than others.
Mm-hmm. And a thought there, follow up for Paul is, say you are served this demand letter. If you're already in process, if you've prioritized and you're working away at it, is there any advantage to getting the process underway?
Well, I think there definitely is, because again, in any litigation, there's usually some sort of preliminary hearing before you actually go into the formal process. And if you, in fact, can tell the hearing officer, or in this case, a judge, we are in the process and this is what we're doing to fix our site, that would go a long way to undermining the validity of the complaint, because you're doing exactly what they tell you you need to be doing.
Yeah.
And again, unlike other types of lawsuits, there's really not damages necessarily. In other words, it's not like somebody's already fallen down and they've been injured and you're saying, I'm fixing the sidewalk now.
Yeah.
Yeah.
Whereas if you're fixing the website, you're actually, in fact, dealing with the actual basis of the complaint. So I think that it does go a long way.
One more question. I think we've had this one in the past, this one from Richard. What about documents on the site? And from that, I'm thinking like, perhaps if it's a banking website, a PDF of disclosures, that sort of thing. Thoughts on documents that are attached?
Yeah, and that's so prevalent, which is a shame. But yeah, they are. It is poor practice to rely on documentation in PDF format. They do recommend that you have it in plain text, and that people that do rely on PDFs work on converting those to plain text documents instead.
Okay, so move away from documents is kind of the answer there,
Yeah.
if at all possible. I thought too. Sorry, Paul. You
Well,
say?
and the other thing too is if in fact it's a certain kind of announcement. In other words, it's you're announcing some sort of promotion or some sort of event. You can provide a link to that particular entity that you are in fact talking about. And then again, and I'm being the lawyer here, but when you are now directing someone away from your site to another site, you no longer have responsibility to make sure that other site is compliant as well. So you've kind of shifted the burden to someone else to make sure they're compliant. And then obviously you need to have the right language on your website to indicate exactly what's going on when you actually direct someone to another website.
Excellent. Yeah. And another thought on that, as far as having documents, if you're having an announcement about, senior leadership, somebody has joined the senior leadership team, it might make for a better blog post.
Right.
So the actual content on your site. So, this becomes beneficial SEO wise, that you actually, get that content out of those PDF documents and up onto your website, text that can be searched. By making your website accessible, you're ensuring that all of your potential users, including those with disabilities, have a decent user experience and are able to easily access your information. By implementing accessibility best practices, you're also improving the usability of the site for all users, and that's from usability.gov. And I think that's the key takeaway here. You may have to make your site ADA compliant, but it's a best practice. It's really it's really why you should be there.
Actually, as we're sitting here and we're thinking, and I think Rafaela asked the question here, if we had the issue of physical locations opposed to the website. And one of the components of the Americans with Disabilities Act is the remediation has to be reasonable in cost as well.
Yeah.
But if you're in a building and it's on the top of a hill and somebody can't access it because they'd have to go up 300 steps, and to build a ramp may in fact not be feasible.
Right.
It may be impractical to actually take the expenditure on. The difference between that and the website is I don't think you're ever going to win the argument that fixing your website is not a reasonable accommodation, that it's too expensive to do.
Yeah.
So I think that's another thing to keep in mind when you're looking at your website is that defense may not be available.
Yeah.
Whereas it might be available if you have a physical location that's very unique in nature.
Yes. Yeah.
Well, thank you so much to everyone who joined us for the webinar. Again, I will be following up. Expect that follow-up email early next week. Thank you so much, Paul, for joining me today. And thank you so much to Raphael for joining us today.